With the first week of the Vice President Sara Duterte impeachment trial behind us, what have we learned so far about the exercise? Is this a purely legal exercise, or rather more fundamentally about our democracy? Has the prosecution team done enough in order to raise serious concerns with abuse of power? Or has the defense team so far shown its ability to potentially prevent an impeachment conviction? What are the stakes in this trial? What are the constitutional issues? What are the likely legal strategies by each side? And what is the bigger implication for Philippine democracy? Is this about impunity, or is this about politicization of constitutional procedures in terms of accountability? To better understand these issues, we have a very special guest. Thank you very much, Justice, for joining us again. It's been a while, but it's good to see you. More fresh than ever. Justice, marami tayong pag-usapan na hindi ganun ka-fresh. Medyo contentious issues in particular. I'm hoping to get your very impartial and comprehensive view as a legal luminary, as a legitimate legal luminary on the upcoming, or actually the ongoing trial of Vice President Sara Duterte. But before that, Justice, I know this is not necessarily directly related to what we're discussing, but how do you keep so strong and so fresh? Parang you look even stronger than last year when we thought. Because I came in so exhausted and dehydrated with the heat and all of that.
Well, just keep exercising and moving as far as I can do. I just came from swimming this morning.
Exactly, yeah. I can see you keeping very active, po. Yeah. And in terms of like diet or anything like that, like do you drink coffee, not drink coffee? Like what are the things that
moderate,
moderate
1 cup a day and occasional wine. Yeah.
Well, that's very important because I had the privilege of also like interviewing Prime Minister Mahathir back in the day, you know, back in 2018-19 when he was here, and he was like 93 back then. Very strong, very fresh. I think power nap and not eating oily food. Yun yung kanyang, and also had the privilege of being in a discussion, actually coming in interview ni Henry Kissinger when he was almost 100 years old. So I can see you for the next 20, 30 years being as strong as them, Justice. Because kailangan namin as we go through this process. So for the next more or less 3 months, although may mga nag-expect na baka tumagal pa ito hanggang Christmas, if not beyond, the impeachment trial of the Vice President will be the preeminent political event for our country. But before we talk about the politics, let's talk about the legal aspects of this. Unang-una, Justice Azcuna, gaano ka mahalaga ito? Ano yung consequence na ito in historical terms? As a former magistrate, how do you look at this impeachment trial?
I think it is a test of our ability to abide by our system of accountability, which is embedded in the Constitution. So it's a test to us as well as to our senators. How well are we going to abide by the rules? And accountability being one of the principal system indicators of our Constitution. So yun ang test. And I hope we pass the test.
And in retrospect, how important is the accountability issue? I mean, of course, in theory, it is important yan in democracy. Pero alam natin, we have had problems with extrajudicial killings. We have had problems with massive corruption scandals. We discussed that a lot last year on different platforms. So does that make it even more poignant, more important than ever, given that bigger picture of accountability deficit?
I think so. Taking into consideration what's going on in our country and around the world, it's very important what will happen in this trial. Yes.
Justice, so last time nag-usap tayo, it was more or less, I think, on the eve of or just before the Supreme Court made a ruling on what should be the proper mechanics to ensure there's proper due process. So just to remind people, ano yung pagkakaiba ng etong impeachment trial sa yung what's supposed to happen last year na hindi nangyari because of the intervention of the Supreme Court? And if we can refresh the memory of everyone, what was your interpretation again of the Supreme Court's intervention and also its final decision to not consider yung motion for reconsideration? But nevertheless, there were some slight nuances there, right? Can you tell us a little bit about the nuances of the Supreme Court's intervention?
Well, basically, the Supreme Court nullified the articles of impeachment in that first Sara Duterte case because of the 1-year ban.
Yes.
They interpreted it in a new way that the ban starts not only from the referral of the complaint to the proper committee, but the non-referral of that complaint within the period provided for. So if the period lapses and the complaint is not referred to the committee, that is deemed initiated, something new, and counted from the end of that period to 1 year is the ban. And the articles adopted at that particular case fell within that 1-year period. So it said it was prohibited by the Constitution. So I said it was unfair because it's a new rule, a new interpretation, and applied retroactively. So normally they would apply it prospectively because the Congress at the time followed the rules then prevailing
Yes.
on when a complaint is initiated under the Francisco ruling. It's initiated upon referral to a committee. But in this case, it was not referred to a committee. Supreme Court said precisely that also initiates it. That's something new. So in any case, in this particular case, it's complying already with all that Supreme Court wanted to be complied with in that decision. So it should be tried forthwith.
And, well, it is happening as we
Yeah.
speak. Justice, pagdating dun sa issue ng due process, giving chance to the vice president, to the accused, to air out her side of the story, wasn't it interesting that suddenly it looks like the camp of the vice president was again asking the Supreme Court to come in and somehow kind of asking them to go against that, like for them not to respond to what was happening in the lower house. Can you a little bit shed light on that? Because there was also a confusion why would Sara Duterte once again seek
Yes.
the intervention of the Supreme Court before this trial started?
Yes, the Supreme Court said that due process must attend an impeachment process all the way.
All the way. Hindi lang sa
And,
Senado.
yeah, from beginning to end, due process must be observed. But on the other hand, it said in a sui generis nature and manner, because this is a unique case, so the application of due process must also be different from the other cases. So what exactly is the due process requirement in an impeachment case? At first, in the main decision last year, the Supreme Court said you have to follow these certain criteria observed in the Antibay case, which is about 9 steps, including proper notice
Yeah.
and all that. But later on, it backed down. It is no longer required. So, because it was pointed out that the Antibay case involved property, loss of property. So, denial of life, liberty, or property is when due process is required.
Right.
But in an impeachment case, there is no threat of denying the respondent of life, liberty, or property because the office is not his or her property.
Yes.
And his life is not endangered. So, just strictly speaking, due process is not required. So the Supreme Court said, well, in a sui generis way, it's required. So what exactly is required?
Yep.
Well, it boiled down to giving each and every member of the committee and of the House, in case the House is the one filing the complaint, a copy of the articles, proposed articles, and of the evidence. That's all. So that was reduced to that. And the need for the House itself to hold the hearing apart from the committee,
Yes.
it said it's optional. And he said, we require that because it's in the rules. It's true, it's in the rules of the House. But he said, that's optional. They don't have to observe it. So, the only thing added was the requirement of a copy to be provided to each and every member of the committee or of the House when the articles is filed by the House. there's no need for the comprehension test,
Right.
which was required that you have to prove that each and every member of the House
Can understand.
understood.
Yeah.
No need. So matras ang court at that time.
Yun yung nuance, diba? Na parang hindi
Yeah.
nila na-reconsider yung motion for reconsideration.
Yes.
But nevertheless, there was some tactical recalibration,
Yeah.
right? Which
Yeah.
is interesting. Like,
Very interesting.
very interesting. You have to
Yeah.
read in between the lines. And,
Yeah.
and I'm very glad, Justice, that you shed light on that. Now, speaking of sui generis, something also exceptional happened just the other day. So you have a presiding judge, which is the Senate President. Now, it happens he doesn't have a legal training. So now you have a presiding officer who has a legal training, and this is the former Senate President, Chizo Escudero. So now suddenly you have two individuals there on top, Sherwin Gatchalian and Chizo Escudero. Aside from the optics of it, which kind of look weird having two gentlemen on top or two individuals on top, can you tell us what is your understanding as a former jurist and magistrate? Kailangan ba talaga na may legal training ang presiding judge? And is there a precedence for a presiding judge and a presiding officer? Because I think a lot of people were kind of confused, if not flabbergasted by it.
Well, the procedure is
Sui generis.
sui generis.
Yeah.
So this particular arrangement never happened before because probably the presiding officer, Senate President in the previous impeachment cases happened to be lawyers.
Yeah.
So there was no need for another senator member to assist the Senate President or to be the one presiding. The question is whether that is constitutional for someone other than the Senate President to preside in an impeachment trial. We searched the proceedings of the Constitutional Commission, and there was a provision introduced that if the President is the one being tried, the Chief Justice should preside over the Senate. And that was approved.
Exactly, yeah.
And another member, I think it was Chief Justice Davide, proposed that we should also include there that in case the others are the ones tried, the Senate President should preside. And then the chairman of the committee, I think it was Christian Monsod, said, do we have to say that?
Yes.
And then so Davide said, I withdraw my proposed amendment. From that exchange, it is concluded that it is now required, in case the respondent is not the president, it is now required that the Senate President must preside.
Right.
I think that's not the only conclusion or the inevitable conclusion from that exchange. Number one, it is very difficult enough to interpret what was said in the Constitutional Commission. It is even more difficult to interpret what was not said.
Right.
So they declined to add that. In my opinion, that can also mean that we leave it to the Senate. We leave it to the Senate
It's their
to provide,
discretion.
to provide for that situation, because that is purely internal. Since it is, you're saying that who will preside among themselves is internal, whereas if you say the Chief Justice should provide, you have to put that because the senators cannot do that on their own. So, but if you say it should be the Senate President or someone else among them, no need to say it because they can take care of that in the rules. So what we did was you simply put in the provision that the Senate can adopt rules to make very effective these provisions. So that's what happened. Instead of saying that the Senate President should preside, well, that you're telling the Senate what to do. That's normal in a parliamentary institution. So there's no need to say that. And it's up to them to follow that or some other arrangement.
Yeah.
In our own Constitutional Commission, in fact, it was not always the President. Palma was presiding. There were occasions who pulled me aside and said, Adolfo, can you preside? And I presided. I was not even a pro tempore or a vice president.
So there was a flexibility there, yeah.
It is, in a parliamentary practice, it is a privilege of the presiding officer to ask someone else to relieve him or her and preside. That is normal. That's not unconstitutional. And that can happen here. This is what happened here. The Senate decided that another senator will be the one presiding, perhaps together with the
Yeah.
Senate president. That's why they're sitting together. And to me, that's not unconstitutional. And that is consistent with parliamentary practice.
From an administrative standpoint, I mean, I get your point, Justice, that there's room for institutional discretion, for creativity, to make sure that this is done in the smoothest and most seamless way possible. But Justice, from an administrative standpoint, do you think it's going to be a seamless process? Isn't it going to be complicated that you have an officer and a judge? Although, to be fair, the office of the Senate President Sharon Gachalan also released a statement basically saying that this is perhaps to make it more administratively seamless. But what is your understanding of that? Could this complicate it?
It's complicated in a way, but then it's something that the Senate can handle. They have enough arsenal in their rules to be able to handle any situation that will arise during the trial. What is important is that the Senate handles it itself. It's all senators. It is actually not a different body. It's the Senate acting or trying a case. If you read the Constitution carefully, the power to try and decide all impeachment cases given to the Senate. And it says, when trying a case, the senators shall take a special oath. They're still senators. There is no new court created.
Yeah.
It's the Senate. It's the Senate trying and deciding an impeachment case. So there's all complications arise within the system of a single body called Senate.
You talked about the Senate having a lot at its arsenal in terms of rules, but this is also an exceptionally unstable Senate, at least until recently, right? I mean,
Yes.
crossing our fingers. But nevertheless, even in the opening hours of the hearing, we saw certain senators, some would say even the former Senate president, they were basically trying to throw wrenches into the machine's processing. Having said that, pwede natin balikan, Justice, ulit yung debate about how do you count the two-thirds majority that you need here, because you have basically one who is a fugitive from the ICC, last time I checked, although I want to see also your because I know you have a slightly different interpretation than that. And then, as of this taping, there was yet another, well, some would say legal luminary for some group, who just surrendered to Sandigan Bayan just the other day. So as we speak, parang nababawasan at least
Yeah.
one faction within the Senate. But you seem to be of the persuasion that strictly we stick to the 16, regardless of what's happening on that front. Because some are saying maybe it's going to be 15 rather than 16.
Yes.
Obviously, we'll discuss later on why that's important, because some would say a 15 is very different from a 16 in terms of getting the numbers,
Yes.
should in case the evidentiary threshold be crossed. But can we go back again to your interpretation? First of all, is Senator Bato a fugitive of the law? And second, are all of these senators going to be counted, both those who have surrendered to the government and those who are potentially wanted by international legal body?
Well, first with Senator dela Rosa, I mentioned that it is possible, in my view, that if he is declared a fugitive and therefore running away from the legal system, he could be considered as having resigned constructively from his position. But that needs a declaration, and he has not been so declared officially as a fugitive. I think the declaration should come either from the Supreme Court in a proper case or from the Senate itself. And the Senate, in order to declare him a fugitive, would require the same two-thirds vote, because that would be equivalent to a removal or of a senator.
Oh, I see.
Yeah, so
even basically declaring his
Yes.
seat
Yes.
vacant would also need.
yes.
Oh, okay.
So that hasn't happened. So that was just a theory, and
Interesting.
to me, he's still a senator. He's still a member of the Senate, and even if he's hiding, and then therefore should be counted in the computation of the two-thirds. The same is true with those who are detained or imprisoned or suspended. They remain senators. And my view is that when the Constitution says two-thirds of all the members of the Senate, it strictly means members. As long as they are a member, they are included in the computation of two-thirds. They may not be able to vote because they could be absent from the proceedings. And the rule of the Senate, the rules right now requires physical presence in order to participate and vote in the proceedings. But they are still counted in the two-thirds in computing the threshold for conviction.
So this is different from the other rule that we were discussing, yung what is a majority in the
Yes.
Senate to decide who's the Senate president? Because there was again a debate on that, whether it's 12, 13, 14.
Yes.
Why is it so strict in here na two-thirds? Pero dun sa issue ng is 13 enough to be a majority or 12 enough to be a majority, on that it seems that there was a flexibility and we have a constitutional precedence that it depends on who's available and who's there.
Yes, the purpose, I think, of being strict in the computation of the voting threshold, two-thirds of all the members, is because the Constitution does not want to treat the removal of high official lightly. The threshold used to be higher, and it has been brought down, but still a supermajority is still a difficult threshold. And the reason is because a high official should not be removed very easily, even if there's a need to account. But the removal itself must be a higher hurdle than normal. So two-thirds of the majority, not just of those present, so that it is more or less a fixed majority threshold that cannot be manipulated
Right.
by, say, arresting or detaining some senators.
And yet we are in an exceptional situation whereby two senators could be facing ICC warrants of arrest. One of them more or less is confirmed. The other one could be confirmed soon. 3, 4, 5 potentially could face different kind of cases. 2 or 3 already have been cases facing non-bailable plunder cases. What if we come down to a situation whereby there are only 14 senators who are not in some way either escaping from law or facing the full force of the law? Does that mean that there should be a mechanism to give them a chance to vote, like from inside detention or from inside a kind of an exile situation? Because let's say Bato does not go through all that process, right? But how do you get him to vote? Or if he doesn't vote, like that's it. Like I'm just wondering about the logistics of it, because I completely see your point. You cannot take it lightly when it comes to impeaching, especially a vice president of the
Yes.
republic, right? So you have to be very strict about that rule. But at the same time, aren't there exceptional circumstances about the logistics of it to ensure all the senators are in a position to cast their vote?
Yes, there could happen a situation where you have less than 16 out of the 24, less than 16 are available to attend and vote.
Right.
And therefore the threshold to convict will not be obtained. There are ways of going around that. One is to allow those who are detained to vote.
Electronically?
Right now, electronically. Right now, the rules prohibit that, but the rules can be changed. That's not in the Constitution. So these are just in the Senate rules.
Yeah.
So when the Constitution says that the Senate has the power to make rules to make these provisions effective. So that's part of it. If it's no longer effective to require physical presence, they can adjust and allow electronic voting to make these provisions effective.
So, in a way, we should have given the chance to the former Senate leadership, because some of them, I think, including one of them who just surrendered, Sanigan Bayan, was pushing for the electronic voting, right? I think they had the foresight that we might come down to this kind of situation.
But the Senate leadership is not part of that. We need to make more effective is this section.
Right.
Section 3 of Article 11, that's only on impeachment. The Senate presidency is not part of that.
Interesting. So like we're gonna that's why it's a moving target as we speak. Now, Justice, let's break it down. So, what are the articles of impeachment, and out of the 4 that we're talking about, what is your assessment? Like, one is on bribery, one is on unexplained wealth, one is the grave threat, and of course the confidential fund issue. Can you break them down, and why are these articles, why are these bases, why are they as a basis for articles of impeachment? And again, we're not going to preempt what the prosecution is going to provide and what the defense is going to do over the next 3 months. But from the available information we have, which one do you think ay medyo mas may leg, medyo may mas threshold of evidence is stronger a little bit on its side? Yeah.
I asked that among my students,
Right.
and the consensus is the threat against
threat, yeah.
the president and first lady and the speaker, because it's easy to prove it came from her, and also because easy to understand. There are no complicated legal issues
Right.
involved. It's just a threat. It's very clear. And it's a serious, very serious
But
matter.
she said it's conditional. Like, it's not gonna, only if something bad happens to
That's
her,
her- that's
maybe
her
something
defense.
happened.
That's her defense.
But that's not, yeah.
Yeah, that's in short, it's easy to appreciate.
Yeah.
So I think the prosecution is starting with that,
Right.
which confirms our assessment that that is the easiest to prove and the hardest to get out from. Yeah.
And you only need to prove one article of impeachment for the impeachment to happen. How is this gonna happen? Like, for her to be convicted, like,
yeah, one is enough.
one is enough, right?
Yeah, yeah.
And you think that could be more or less a smoking gun. Now, what
It
about
could
the
be.
other three? The is many feel is the weaker one. The confidential fund, which I think also got a lot of attention, and also the unexplained wealth, especially the bank account expose or alleged expose that happened actually first with Senator Trillanes
Yeah.
back in 2016,
Yeah.
March 2016, and then again in the House of Representatives earlier this year. How do you read the three other charges, and what could be the potential strategy? Because more or less on the grave threat, all the
Yeah.
prosecution has to do is like listen from,
Yes.
basically her own words, right? And we more or less know the counter argument would be it was a conditional threat. I don't know if they're going to say it's joke, but she said no joke. No joke, no joke. But the other three, where do you see this coming? Ano yung magiging strategy ng each side to make their case?
The others are financial matters, the non-declaration of wealth. Again, financial depends on the financial records, the failure to account for discretionary funds, financial accounting then. So it boils down to numbers and records. It's easy to dispute that.
Yeah.
And easy to justify it. What would probably remain as a possible difficult hurdle for the Vice President is betrayal of public trust. So those two, the threat against the President and family and the Speaker, plus betrayal of public trust, because betrayal of public trust is not specifically defined, so it can cover any act that renders an official unfit for governance. And it's very broad, can mean anything.
Catch all, yeah.
Yeah, so it's a catch-all, so it's something that she has to watch out for. You don't know where it will come from. And so that, and the one that's very easy to understand.
The grave threat.
Yeah.
Now, let's look at this, because the conventional wisdom is on one hand, the 16 will be very hard.
16.
Yeah, precisely because of the political alignments. And yes, the popularity of the Dutertes, which is undeniable, including the fact that almost all pre-election surveys suggest that Sara Duterte is still a favorite to be the next president of the Philippines. But the conventional wisdom also says that, like, it's going to be so politically damaging to her. I mean, everything is going to come out. And therefore, regardless of whether she gets the conviction or not, this is going to be a game changer. Where do you stand on this? Because Justice, there are also other ways of looking at it, right? You could say that maybe if the evidence is very clear on not only one charge, but multiple charges, even the other senators who were seen to be more sympathetic to the Dutertes or closer to Dutertes for their own political survival, they don't want to be part of a sinking ship, right? And that brings you to the second part, which is public opinion. That once the people see more and more evidence, then even some of the supporters of Sara Duterte may change their mind. For me, though, is like none of these are set in stone because, I mean, on one hand, what else should people say? It's not like yung grave threat ni Sara Duterte, people didn't see it. The Miggy Mango, Piatos thing, I think this has been out there for a while. And sometimes I wonder if you don't get the magic 16 to convict her, regardless of the threshold of evidence, it's also very possible that a lot of people will still stick to her, no matter what. So what is your read of this? Because ultimately, as you said, this is a sui generis event, but it's also a political event. It's not just a legal event. It's about political alignments, loyalty, and calculations. Yes. And I'm not very sure what else some folks need to see to change their mind about whether there's a betrayal of public trust or fitness for the office. But you tell me, where do you see this going? I mean, again, it's going to be a long process. We're looking at months here. There's going to be a lot of twists and turns. But if you were to bet right now, what is the most likely scenario? Of course, we're not in a prediction game here, but what is the most likely, or what are the most likely scenarios for you, Justice, moving forward?
Okay, it's very difficult to predict what will happen. But for certain, the people are watching, and this whole exercise will have an impact on the elections.
Yeah.
And I think prosecution is aware that it will be very difficult to get the 16 votes, given the present leanings.
Yeah.
And therefore, what it will do, or seeks to do, is to present all the evidence that they have for the people to see and judge for themselves whether or not the respondent is fit to hold a high public office. And if it does that, whether or not she is convicted or acquitted, doesn't matter. What matters is the people have a basis for judging, come election time, whether or not she should hold the highest office. So I think that's one possibility. However, supposing they convict, okay, somehow.
Which is still unlikely at this point, but there's a little possibility,
Supposing they convict. So, she's removed from office, she's disqualified from running, so the people can no longer judge her. There is no room for the people to render their own verdict. So in a way, a conviction will preempt the people from judging. So I have a proposal. Why? There's another theory. Is it possible for the impeachment court to convict her
but not
for
disqualify
removal,
her?
But not disqualify her? Because the Constitution says, judgment in the impeachment cases shall not extend beyond removal from office and disqualification from holding any office under the Republic. It should not extend beyond. It can extend below. Extending below means you can remove but not disqualify. Supposing they have separate voting, which is not prohibited by this Constitution. It's allowed in other systems. We vote first on removal. 16 votes, removed. We vote on disqualification, only 15. So she's removed but not disqualified. She can run again. Then the people can judge. Is she fit to be president? And yet the condemnation is there already. She's removed. Is that possible? The Constitution doesn't seem to require single voting.
So there's a gap that there's an openness there. There's a loophole there, you could say.
A gap or a what do you call a
silence? Is the Constitution silent on this issue?
Yes, possibility, a flexibility in the Constitution.
So I have two points of contention with that perspective, Justice, and that's why I like this discussion. One is, we already have a representative democracy system, meaning the people have already spoken through the senators they have chosen. So these senators are already speaking in behalf of the voters if they decide to convict her and disqualify her. So why should we wait for the direct vote of the voters as the only expression of their sovereign choice, right? The second argument I have, which is even more controversial, is you seem to have a lot of confidence in our voters, which is, I am all for empowering our voters and all of that. But I also know that, I mean, I don't want to get more persona non grata than I got last year, but I know for a fact that, we have very strong regionalistic tendencies in our countries. Again, let me get in trouble with my people. Solid North, right? Like, I've known many relatives, many people, no matter what facts you present them, they believe democracies are the best thing that happened to the Philippines, right? And so a part of me believes, no matter how much facts we present here, no matter what basis for judgment people have, it's going to go down to some of these really emotional and ideational factors when it comes to it. Maybe we can debate about whether it will be the magic number of 35, 40. I mean, that's going to be an election debate. Like, you could say, yeah, but there'll be a reduction here. Therefore, maybe Lenny gets this, maybe Rafi Tulfo gets this. But for me, a part of me just has a general, I would say, ambiguity vis-a-vis this idea that direct voting is the only way to ensure accountability. Because you also create another problem, Justice, right? Which is then election cycles every 3 to 6 years is the only way to hold high officials accountable. Because that's going to be the implication of that, right? You tell me, like, what do you think about it? Because for me, the whole point of having representative democracy is because you don't want to wait for every election and basically a popularity contest to dictate issues of accountability. Because rule of law is precisely to go beyond popular expression of sovereignty alone. Of course it matters. That's why officials are there based on their electoral mandate. But that's not the entire picture. That's not the only way to ensure accountability. I don't know, Justice. This is the political theorist in me pushing back a little bit against that legal interpretation. But I want to hear your point of view.
Well, elections, both popularity contests as well as sovereignty contests. People are sovereign. And ultimately, the people is a repository of the choice, the leaders. There is a strong move now to shift to parliamentary because, in effect, we cannot trust our people to choose the leader. They might choose always as actors, not competent to lead us. And it's hard to change. Impeachment, very difficult. So whereas in parliamentary, very easy to change the leader. So when we were drafting the present constitution, we went out to the provinces and asked the people what kind of system they like. At that time, they wanted presidential.
Right.
And why? Because they want to be the ones to choose the leader, not the representatives. So I don't know now, would our people, if you ask them now, would they still want to be the one to choose the head of state and head of government? Yun ang ano eh. Given the bad experience, quote-unquote, with the presidential system, where I was for parliamentary, by the way. Would they now favor parliamentary system? So,
I mean, I've been based in the UK for the past year, and I think they had, 5 or 7 prime ministers over the past decade. Like, medyo magulo rin ang UK as we speak, right? Like that. So, and UK is the oldest, like, Westminster parliament system. So, I also don't have illusions about that. And looking at people like Boris Johnson doing so well back in the day, they also have personality-based politics. It's not like people voted for Tory back in the day because they loved Boris Johnson. He was such an exciting individual, right? In fact, with some friends in Oxford Union, I was suggesting we should make a documentary about him. Ang title was Velocity of Ego. But what I'm saying is that wala rin naman ako illusion about the parliamentary system. But what I'm clear about is, the rule of law should go beyond popularity contest. And I think by nature, presidential elections are a popularity context, right? And that's precisely why you have to have other institutional arrangements, right? To make sure hindi ka lang maghintay every 6 years to have accountability and to ensure you have the foundations of the rule of law. I know we're a little bit tiptoeing around this, but these are serious issues, Justice, right? Last part, Justice, moving forward, what do you want to see in the upcoming trial that you feel will contribute to making our democracy more mature, to making our voters more forward-looking? Because in defense of our voters, and this is where I'm going to actually make the other side of the argument, for instance, last year nakita natin marami mga, again, I have nothing against mga artista, a lot of them are my colleagues here, but we saw a lot of artists lost, right? A lot of celebrities did not make it, right? And a lot of very competent people with very limited resources were able to make it to the Senate, for instance, right? So we also see the ebb and flows of that. But nevertheless, what do you want to see and what do you think is important na lalabas dito sa trials natin in the coming months para hindi ma-trivialize ito, para hindi maging toxic partisan exercise ito? Yes, it is a political exercise ultimately. It's sui generis. But ano yung mga minimum na kailangan to make sure ito ay best possible scenario for our democracy, for our country?
I think as I said, this is a test. Whether or not we can abide by the rules that we ourselves adopted. And these are set out in the procedure for impeachment. And I hope that it's off to a good start for me. Prosecution, defense, the Senate itself, so far, it looks like they're following the framework provided in the Constitution. So I hope it plays out, regardless of how the verdict will come out, as long as the prosecution is given all the chance to present their evidence.
Yep.
And the defense, likewise, given all the chance to defend the respondent. And then the senator judges, of course, render the judgment based on their oath to be impartial.
Yeah.
A political judgment nonetheless, but still to the best of their ability based on the evidence and the law. So hopefully that's what will happen. And then the people participating all the way through the coverage, the very extensive coverage available under present technology.
Yeah, exactly, yeah.
As well as the participation of civic groups helping the people monitor what is happening. So all this, I think, is a democratic exercise. And the exercise itself is, to me, the best happening for the people, regardless of the results later on, or conviction or acquittal. The process, the medium is the message.
We started with your swimming exercise. We end with the democratic exercise. Thank you very much, Justice,
Thank you.
for that very comprehensive discussion.
Yes.
Hopefully, pwede kitang disturbayin more later on and in the coming weeks and months. Also on the issue of flood control and corruption. Marami din mga pwede natin pag-usapan yan. Catch us again next week here on One News. You can also check out the long conversation on Spotify and YouTube. I'm Richard Heydarian, and that was the view from Manila, where One News, all sides, all the time. Just as postscript lang, this is very important. Balikan natin yan. I mean, one of the reasons we became beshi and good friends is because of our shared anger at corruption, particularly yung flood control scandals last year. This month, SONA na naman ni BBM. So this will be the SONA after the SONA he exposed and admitted to all of this kababalagan sa ating sistema. Where are we in our fight against corruption? Are we following the original timeline? Kasi alam ko, dapat December pa lang last year, marami nakulong. But so far, konti lang eh. And some are saying parang selective justice. Most of the people are facing justice now are actually from people who are from the opposition. What is your take on the corruption and what should we do in the remaining months of the year?
I think we are still awaiting the big fish and the real serious attempt to unravel these billions, if not trillions, of corruption, as well as the restitution of what was stolen from the public. I think it is here that our system needs to be changed. We are uh, adopting the system of the U.S.
Yeah.
When we should adopt the system of England. In England, there is no need to prove ill-gotten wealth as long as your income is insufficient to cover your wealth. The gap is automatically forfeited.
Yeah.
There's no need to prove that it's ill-gotten. In our case, we have to prove that the excess was ill-gotten. And according to my friend who is a judge in England, that is impossible to prove.
Yeah.
So what they do in England is just prove the discrepancy. And the moment they prove the discrepancy, the extent of the discrepancy is
Suspect already. Oh.
automatically forfeited already. And if we do that now, can you imagine?
So you reverse the burden. They now have to prove
Yeah.
why is that gap justifiable,
Yes, yes.
not us trying to prove that,
Correct.
because that will take forever
Correct.
and they'll get good lawyers and all of that. And you
Yeah.
think that will deter corruption?
Yes, I think so. Because what we do now is we don't go after the wealth. We go after the person. We want to imprison him.
Yeah.
So what do? They get hospitalized instead.
Yeah.
Suddenly they get sick.
They have
so they cannot be
neck
sent to
brace,
prison.
wheelchair. Yeah, exactly.
Forget the prison. In the first place, we don't have decent prison facilities.
Yeah.
So go after the wealth. That will stop them. Because why did they steal in the first place? They wanted the wealth.
Right.
Get it back. And
So you think that's the more efficient
that's
system?
the
no?
approach. That's why I am proposing a new writ called quitam,
Yes.
which will authorize a private citizen to sue on behalf of the government, a public official, for ill-gotten wealth with a possible share, a little share, in the recovery. That was proposed by the late Senator Miriam Defensor
Right.
Santiago,
Right.
patterned after the False Claims Act of the U.S. But it was not adopted. Precisely, they were scared that
I'm sure there's not much interest to adopt that because next thing you know, daming private citizen
Yeah.
nakapila because there's so much unexplained wealth. You just
Yeah.
go to the Instagram pages of
Yeah.
some of these people. Where is
So-
that coming from? And last point, Justice, ito na yung parating ng SONA ni President Marcos. How important it is, I mean, still we have a few weeks left, to make sure that at least a couple of big fish, I don't know how you pluralize that, ay dapat makulong. Hindi ba sapat na meron na tayong a couple of senators at least, a couple of contractors at least there? Should we see more cabinet members? Should we see more senators and congressmen, Senate President, Speaker? What are we looking at? Again, I know the ombudsman doesn't have an easy job, but at the same time, like people are waiting for something, right?
Richard, I don't expect that to happen. What I only hope is to stop the hemorrhage.
Yeah, correct.
Change the way we adopt our budget and put the citizens in a position to monitor the procedure of adopting this budget. So stop the, they'll find another way.
Yun nga
That's the problem. So stop this other way.
I-freeze mo muna yung,
Continuous monitoring.
Yeah.
Make the whole thing transparent. And forget the billions. You have lost it already. But prevent the future
Trillions.
Billions.
Future trillions,
Yeah,
actually.
that's
Yeah.
it.
Exactly.
prospective remedy.
Exactly.
We're not good at recovering what has been lost. But I think we are good in preventing future possible losses. That's what we should concentrate on. That's what the SONA should tell us how to do it.
In the succeeding budgets, no?
Yeah,
We have
succeeding.
transparency and all of
Yeah.
that. I'm sure many will agree with your first proposal, but on the second one, that maybe we'll forget about the past. I'm sure many will disagree with you on that. But Justice, thank you so much for your very sober
Thank you.
and very sound advice, legal advice, dun sa
Thank you.
mga pangangailangan natin sa ating bansa. And yes, on that, I'm with you. UK has a better system. You don't see massive corruption scandals in
Yeah,
UK
I
in the
don't
way
see
you
it.
see in a lot of presidential
Yeah.
systems. No, so I do actually agree with you on that point. Thank you very much,
Thank you.
Justice.
Thank you very much.